Well, it is great to be with you today. My name is Diane Ronaldo. I am the Executive Director of the Open RAM Policy Coalition. Prior to that, I was the Deputy and then Acting Head of NTIA, the country's tech and telecom agency. And before that, I was at the House Intelligence Committee, where I was tasked to do tech, cyber. I was also the NSA oversight person. I joined that job under Chairman Mike Rogers, who wrote the Huawei report. So I have been following these issues for quite some time now, and appreciate the topic today and being asked to participate along with Mark Cohen and John Putnam, and I will let them introduce themselves. But we did a call just before Thanksgiving, and that hour flew right by, so we will definitely not be lacking for information. I know that we typically do questions at the end, but I also think it's very interesting for you all, if you have questions in the middle, please feel free to raise your hand and we can take it right away. I prefer interactive sessions, so if you are okay with that as well. Sure. Okay. Well, I will start with Mark to my right. Would you mind introducing yourselves and giving a little bit of information on your background?
Sure. So, the general principle is the longer the title, the less important you are. So I have a long title. Unlike my colleagues from Berkeley who have shorter titles. I think, Bo, you have a shorter title. So I direct a project on intellectual property in Asia at Berkeley Law, and I'm also, I teach there and do research there. And before that, I was teaching at Fordham, and before that, 13 years in U.S. government, including serving as the first representative of the USPTO at the U.S. Embassy in Beijing, and a bunch of other stuff, private sector, academic, and in-house. Thank you. It's a pleasure to be here. It's about 40 years of work on Chinese IP matters for me, including my first involvement in licensing transactions were in the late 1980s.
Great, thanks, Mark. We're lucky to have you. John?
Yeah, I'm John Putnam. I'm the principal at Competition Dynamics. We provide economic testimony in intellectual property litigation. I've been working on IP since I wrote my dissertation on the international patent system 25 years ago. And I'm here, I think, in part because of a paper that I've written with colleagues at Competition Dynamics on examining Chinese patenting and the effect of inflated Chinese patenting and subsidies on the quality of the patents that are issued in China. And that's a sort of an exemplar of a more general approach to intellectual property that I think we'll be getting into at length today.
Great, thanks, John. So as we discuss these issues, I think you can say that policymakers, academics, social media prognosticators spend a lot of time opining if China is a threat. Maybe today we can just bypass that and say, yes, they are a threat. So I would like to focus the conversation on what makes them a threat to 5G, a threat to national security, and that's also including economic security, and a threat to IP rights. So maybe we could start with a high-level question. John, if you want to go first, and then Mark. Where does the United States sit in relation to patents with China? And what should be our metric as we look at these numbers?
We investigated, actually on behalf of a client, the question, has China won the innovation race, either globally in all industries or in 5G and other strategic industries? And to do that, we built a model of worldwide innovation. Innovation is, of course, a worldwide competition. And so sort of like if you're fishing in a common lake, you would expect people who are fishing harder or more frequently or have more fishers to catch more fish. China's numbers have exploded in the last 20 years, and in the last year for which we had data in our paper, there were more than 1.4 million patent applications filed by Chinese residents in China. By comparison, there's fewer than 300,000 filed in the United States. So the question is that number real based on the actual inputs that China brings to bear on innovation? And long story short, the answer is no, it's not real. The true number is something more like 200,000. China's innovation is actually growing rapidly like the Chinese economy, but it just doesn't have the resources to be producing 1.4 million patents per year. So this is a pretext, and it's part of a larger strategy. And it shows up in sort of global competition, but it also shows up in 5G. So part of our paper is to analyze the quality of 5G patents and to say, is there evidence that Chinese 5G patents are higher or lower quality than average? The answer is they're lower quality, and it's declining. So I bring this up to say that I think that there are, the United States has to face the fact that it's, if you're going to treat China as a threat, I think two things are true. One is it's got a determined adversary who is willing to monkey with the numbers. But then the other fact, which I think is probably more interesting and more important, is that in many areas there aren't good norms for saying what a country ought to do or what a country's national interests are when it comes to IP. And that's a very complicated question, both domestically and internationally. And I hope we'll have a chance, I know Mark's done a lot of work on this, we'll have a chance to explore some of those political and legal tensions as well as the pure economics.
Mark, do you have any comments on that? And I'd also like to add a specific question for you. Do you think the United States is late to the game recognizing China as an economic threat on these issues?
Sure. So let me take that last question first, because even though any of those questions could easily consume a day, if we had this meeting 5 or 6 years ago, with the exception of companies like Qualcomm and a few others, most of the focus when we talked about IP issues in China was on counterfeiting and piracy. In fact, many people would say, I think primarily before Trump came to office, that China will never innovate because it's a communist country and communist countries don't innovate. They imitate. They don't have the market mechanisms. They don't have the incentives. Even the concept of IP theft, which is, however vague it might be, you go back to congressional testimony of 15 or more years ago, and you'll find that the concept meant counterfeiting and piracy. Nothing to do with patents. Zero, and I cannot overemphasize this, zero to do with patents. I recall when I was in the government in 2002, and we were submitting the first trade review mechanism questions to China after China joined the WTO, and I said, what about trade secrets? And USTR said, what about trade secrets? I said, I think we have a problem with trade secrets in China. Well, no one's complaining about that, Mark. So I drafted the questions, USTR submitted it, and I called them up after I prepared my questions. This is in the WTO database. I said, my computer is not working well today. I had to do this very quickly. And there's a space between T and S in trade secrets. Can you please remove the space before you file? They never got around to it. And you'll see there's about 8 misspellings in the request submitted by the US government. There was not even interest in copy editing what I prepared. And so we should be really careful about misunderstanding our own concerns about China. We were not there engaging with China on innovation issues. We were not there engaging with them on trade secrets. We were certainly not there engaging with them on patents. So that is, I think, a very big misapprehension. And in fact, when we filed a WTO case in 2007, BSA, it was on copyrights and trademarks. Business Software Alliance was not supportive of the case, and there was 0 on patents or trade secrets. And there was 0 on civil enforcement of intellectual property. A lot of talk about criminal remedies, but nothing on civil remedies. So this is a pretty systemic, deep issue within the US government, in part a high degree of reactivity to industry concerns. And that gets us pretty closely to the moment we are in now, where some of the work from John Putnam and others about patent subsidization, low-quality patents, there's a rather aggregated, need to be disaggregated approach on understanding where China is. I don't know how many articles come out every month. China's out inventing us in AI. Look at China in IoT. Look at China in biotech or whatever, any other area. And most of these raw numbers reflect a planned economy approach to intellectual property. And it's very hard, I think, for Americans, people in the West, to understand what that means. If you go back to the WTO accession, when people talked about pre-China, if people talked about Eastern European countries joining the WTO, there's an article in the WTO about that, in the TRIPS agreement. We'll give them extra time. They don't understand intellectual property. They barely understand property rights. After all, it's a socialist economy. Sometimes you couldn't even own your apartment that you lived in. And all of a sudden you have this embrace of a transition or socialist market economy of intellectual property, so that you have 5-year plans around intellectual property. No one expected that. What does that mean as a tool for that economy? John talked about that. Is that potentially not just disruptive, but pernicious? Is it disruptive to the intellectual property system generally when you don't have the same respect for private rights? And that's in the preamble, by the way, to the TRIPS agreement, that intellectual property is a private right. And if you want to know who submitted that request, it was the British colony of Hong Kong, probably thinking about what it's going to be like when Hong Kong reverts back to China. Is actually very perceptive. Now, friends of mine will say, well, gee, Mark, a patent right is granted by the state, a trademark is granted by the state, put aside common law rights for a moment. This is really, talking about private rights, it really isn't a private right. I mean, that's a long discussion. We're talking about oil states and other cases in the US. But if you look at this, not in terms of black and white, but in terms of a continuum, it is true that North Korea has a patent clause in its constitution. That doesn't mean it protects property rights. Probably doesn't mean that the Constitution is very significant either in evaluating their IP regime. But we're looking at a continuum where, for example, aggressive subsidies distort how to understand China's patent filings or China's participation in SDOs, or even the significance of what people used to use as a benchmark, PCT filings or triadic filings, because China generally only subsidizes overseas applications to 1, perhaps 2 countries. You're not going to find multi-country national phase examinations of PCT filings. It makes it a less valuable metric. We have to be really careful in evaluating the threats by China, because you have such a huge number of distortions. Now, that does not mean, and I don't think John was implying this, that we should be complacent. It's all junk. That's not true. There could be a lot of high-quality patents hidden in the junk. And I could give examples of that, but it does mean that we have to be really careful when we identify areas of concern. AI, for example, China, I think, is clearly a leader in facial recognition technology. That doesn't mean that the US isn't a leader in other areas of AI. And particularly if you start putting on qualitative glosses like highly cited scientific publications or highly cited patents, you start coming up with a very different picture.
That's great. Thank you. So you make a good point, right? Technology is iterative. So what is considered junk patent now could be very useful to something down the road. So do you think that U.S. patent technology is keeping up with the times?
Well, I think the U.S. has had a very high degree of self-inflicted harm by evolution in U.S. patent doctrine with Alice and other cases. So I think we have to be careful about how we manage this. We can't blame U.S. Supreme Court decisions on patent-eligible subject matter on China. And there have been several studies done, including by Adam Mossoff here at GMU, that have shown that Americans have been able to obtain patents in China on technology that they were unable to obtain patents for in the United States. In fact, around the same time that Alice came down, China was revising its patent examination guidelines to improve patent eligibility for software. It almost seemed like China was trying to eat our lunch. I don't think they were. They just recognized that under their own 5-year plans, 15-year plans, they needed to make it easier for people to obtain patents in certain sectors. I am reflecting on that. I think the problem isn't so much what China was doing, is that the U.S. Supreme Court doesn't have a 5-year plan. If they understood that these technologies are important to U.S. development, they may have relied a little bit less on the New York Times or whatever the sources of information are about patent trolls or software patents destroying the U.S. economy, and they might have come to some conclusion that this is really important to maintain talent and incentivize innovation. So I don't think that China is at all to blame for everything. And in fact, I think always the strongest weapons in the United States are what we can do to strengthen ourselves.
John, can I give that question to you as well? Do you think that patent law has kept up with the evolution of technology?
Well, I think that I'm not a lawyer, and so but I'll give you my economic perspective. I guess I would say China is determined to be a technology powerhouse, and they are investing enormous amounts of money in technology, and given the rate of growth of their economy, they will eventually surpass the United States in size. You just have to say that. They're 4 times as big in population, and their GDP is roughly half of our size. You just have to plan for that day. They're planning for that day. What that means is that they are laying the foundation for a stronger system of patent rights, because eventually they will be a net technology exporter, and they want to get rewarded like a net technology exporter would get rewarded. In the meantime, while they're a net technology importer, it serves their interest to have weak patent rights, or weaker patent rights. And so we're in this transition period where the rights are strengthening but still not strong. The US, on the other hand, I think is in a period of weakening patent rights. And the ironic thing is that there is a substantial community within the United States that has interests that are better aligned with China's, at least in the near term or the intermediate term, than with the United States' interests. And we talked about this at length yesterday, and I won't go into that. But so the answer to your question is, I think that because we don't have a long-term plan, and because there are substantial people who benefit from a weak patent right regime, there is no, I would say there's not a strong reason for optimism that the patent system will continue to serve the interests of the United States as a net technology exporter. And one could imagine a world 15 years from now where China has, a comparative advantage in the production of technology.
So,
I might just
please,
add
no, go ahead.
one point to that, because it's something that I think most people in the U.S. are extremely unaware of, which is that the Chinese IP regime is much more friendly to small inventors, small creators, whether enterprises or individuals, than the U.S. system, by almost any measure. Litigation is fast. 6 months, first instance litigation, typically 7 months for a patent, 3 or 4 months for a trademark or copyright. It's inexpensive, low cost of discovery, actually almost non-existent discovery. You have inexpensive rights like utility models, and China's utility model, petty patent regime, is several multiples of the multiple that it already has compared to invention patents. I think China's up around 7 or 8 million utility model patents. And litigation, about 30% of the court cases are filed by individuals, small companies. You compare that to the U.S., independent inventors, 5 to 6%. You want to get a macro entity designation from USPTO, you have to file it with each application. China will give you a year or two to file multiple patents as a macro entity or get a preferential treatment. Design patents, you'll get them in 2 to 3 months. Utility patent in a month and a half or 2 months, granted from the Chinese Patent Office. This is really a very different system from the United States. This is maybe the better side of having socialist intervention in the IP regime, that you can try to spread the wealth and engagement on IP issues. I think the average Chinese IP judge is far more educated on IP judges than an Article III judge of the United States. I think the average Chinese citizen has seen more exposure to IP issues than the average U.S. citizen. I was interviewed when the U.S. filed the WTO case against China in 2007. At that time, I had 170 million people listening to me, twice. That is a high degree of public involvement. Specialized law faculties. When I was living in Beijing, I was one of the subscribers to the intellectual property newspaper published by the Chinese Patent Office 3 times a week. Just a very different regime in terms of engaging the average person. Now, how much that adds up to a strategic advantage, or whether you're empowering trolls and low-quality patents, hard to say. But I do think, on balance, that view that the patent or IP system is available to all is a net positive for China and a strategic advantage.
Yeah, if I could just add to that from personal experience, being working for Congress and the Energy and Commerce Committee and the House Intelligence Committee, when the OPM hack happened, we had a big classified hearing for members of Congress, 435 members. Not that many attended, but it was a well-attended event. Any guesses on how many questions? Secretary Johnson and a panel full of very senior executives for the administration? 3. First 2, what's going to happen to my information? Only 1 question about the underlying attack. So I always go back to the lack of education within our own Congress, within the members of Congress and their staff on these issues. And I feel, from my own point, that's always kind of been a hindrance of advancing good policy, is because you hear technology and people are uncomfortable, so it always gets backburnered.
Yeah, let me just add another point. This comes up in my slides if we get around to it. But how often have you heard the President of the United States deliver a speech on intellectual property? I think unless you're about 150 years old and you heard Abraham Lincoln's lectures, I don't think that's ever happened. Yet in China, it's at least once a year. And these are very important speeches, and everybody pays attention. The other thing, which I've tracked kind of informally, is mobility. How often do people involved in IP get promoted to higher and higher positions? And I can tell you in China, it's with a high degree of frequency. A judge who becomes a senior judge, maybe a chief justice. We've never had a federal circuit judge become a justice of the U.S. Supreme Court. Yet I've seen migration well beyond intellectual property of some of the younger Chinese officials. And this just shows how deeply it's been incorporated into their economic DNA.
So John, I'm not a lawyer either, so you're good company on this panel today. Are there policy tools that could be implemented, that need to be implemented to write things? I mean, Mark was talking about there's no incentive structure. Are we just doing it all wrong and kind of need to go back to the drawing board?
Let's see.
See, I told you we wouldn't be lacking for information today.
I'll try to fit my answer into the next hour and 15 minutes.
Good.
I think that a couple years ago, I had my house was badly damaged in a flood, and I had to get advice on how to fix it. And the advice, sort of fell into, contractors are also good economists, so they would say, well, on the one hand, you could do X, and on the other hand, you could do Y. And on the one hand, it was always put a Band-Aid on it, and the other hand, it was rip it out and start over. Since I was investing for the long term, I own an old house, we always ripped it out and started over. And that's sort of my view of what needs to happen with, if we're ever going to actually make progress on a world trade regime for intellectual property rights that is welfare improving and that people can actually point to a common intellectual framework and say, here's what we ought to do together. We might disagree on, the institutions and, there's various competing rights and everything like that. But right now, we don't really have, we have a system of international trade that is based on a static and comparative advantage-based intellectual framework for trade, and that's not really what you need for intellectual property. So if we're going to ask the question, what is a national security issue and what is the national interest, then you need an intellectual framework for articulating what that is. And if you're going to start there, then you've got to go, start ripping out the things underneath that that are going to give you, that are giving you the wrong answers, that are preventing you from getting the right answer to the ultimate question that you care about. So let me give you an example. Antitrust policy, okay? And I'm talking specifically about SEPs, not just sort of international trade generally, but since this conference is about 5G and the Internet of Things, I want to focus on how SEPs actually screw up the world from an economic perspective. And I mean that not in an anti-SAP sense. I think it's a fantastic thing. It screws it up from the analytical framework. So, antitrust. The cliche of antitrust is that antitrust protects competition and not competitors. And so the FTC and the DOJ bring to bear their analysis of competition in the context of SEPs. The problem with the standard setting process is it's not what an economist would call a competitive process. So to say that you're protecting competition is actually a complete misnomer. Why is it not a competitive process? Because it doesn't have prices involved. When I was in graduate school, I had a professor, we all sat in the first year, and it was completely mathematically bewildering, and finally the professor turned around and said, okay, whenever I go like this, I want you to all say prices, okay? And so he would raise his hands, we'd all go prices, and that was the basis for the whole notion of economic equilibrium. You don't have prices in standard setting. You have a bunch of engineers getting together and assembling a coherent thing without prices. And that's a very extremely valuable activity, but it's not what you would call a competitive activity or an optimizing activity. So to say that you're going to protect competition in that environment is actually a complete misnomer. So what you need to do is develop an analysis of price setting, or how you think prices ought to be set, when the agents themselves are not relying on prices in order to engage in their optimizing activity. I worked on the FTC Qualcomm case. I worked for Qualcomm in that case. And I was actually really excited because this was a big case, and I was finally going to get past all of the implementer crap that you hear, the lack of analytical framework. And I'm going to hear from the U.S. Federal Trade Commission about what their theory is, what an excessive price is that Qualcomm is charging, because that's how an antitrust agency defines market power, is with respect to the competitive price level. And so I was really excited. We're going to get the best minds in the government. They're going to explain what the competitive price level is and why Qualcomm is pricing above that. We got absolutely nothing of the kind, because there is no such thing. The government's theory was they pulled out, a handful of Apple licenses and said, well, we think that Qualcomm's charging too much in relation to these. That's not the basis of how you can formulate a coherent antitrust policy. And the same thing is true of intellectual property. Intellectual property promotes progress. We all know that. Well, what does progress mean to an economist? It means you're rewarded in proportion to your advance over the current state of the art. That's not what happens in the standard setting process. In the standard setting process, there's one person who wins and everybody else loses. It's a winner-take-all environment, with respect to an individual contribution. So the standard consists of a whole bunch of winners who deserve winner-take-all rewards for their invention, because everybody else who invested in making a contribution and wasn't selected gets nothing from that. How do you determine what the winner-take-all price for the piece of intellectual property is that is eventually formed into the standard? There's no framework for doing that. We want the benefits of that winner-take-all competition. Why? Because like in a golf tournament, the person who wins the Masters tournament doesn't get rewarded based on the number of strokes by which they beat their competitor. They get rewarded based on whether they won. And so you have intense competition down the back nine on Sunday, people trying to work as hard as they can to get a one-stroke advantage, because the difference between finishing first and finishing second is so huge. And the competition is better as a result of that. Both golfers play better because of that enormous difference at stake. So looking at the next best alternative to the invention that's chosen into a standard is not the right way to think about the price from an economic perspective. So then you can just go on and on and on and on and sort of keep ripping out all the stuff that is damaged by the flood being the introduction of SEPs into what is nominally a market competitive process. And you have to actually rip it all out and start over again in order to have a coherent framework. And once you do that with respect to markets and trade, then you can eventually begin to make progress on saying, what is the national interest and what is a national security issue? So to say, do we have tools? The answer is, well, we have tools, but they aren't founded on a solid intellectual foundation. And you're eventually going to run into problems unless you actually diagnose those problems in advance and say, here's why I expect the system to fail, given why these tools will eventually fail, given our current intellectual foundation.
Yeah, I'd like to add a few observations from my time in government service on this question. If you walked into a U.S. embassy anywhere in the world, small one or big one, Belgium, China, New Delhi, or some other place, you say, go to the commercial service, and I'd like to speak to the person who helps American companies sell technology to this country. Do that sometime. Nope, such person exists. Nowhere. We're the largest technology exporter in the world. Official data from U.S. Census, about $140 billion a year, but I think there's more than that because of tax havens like in Ireland, Luxembourg, et cetera. And we basically have a trade policy that looks like the United States in the 1940s. You know, steel, grain, hard goods, some services, but not intellect. And frankly, if you go to the census data, you want to look up how much the U.S. exports in technology, you have to know the secret password, which is that it's classified under industrial processes, exports of patents, licensing of patents, assignments. Unless you know that, you won't even know where to look. And they don't even publish all the data that they collect. This is not a licensing or 21st century oriented trade policy, nor is it staffed accordingly. This week, Kathy Vidal had her confirmation hearings. We're a year into the Biden administration, 25% of the time has gone by, and we're finally getting a PTO director. And frankly, while that's important, the really important confirmations were much earlier with Catherine Tai, who is really the senior most official who is consistently engaged on international IP-related issues as U.S. Trade Representative. And next week, I believe, a newly confirmed Ambassador Bianchi is going to be negotiating or talking about the Phase 1 trade agreement with China, including its IP aspects. Neither Bianchi nor Catherine Tai has any significant experience in China. Or in IP. In China, yes, but not in IP. In fact, the office that she sat on, Catherine Tai, on trade enforcement before she went to the Hill, rejected for 2 years my proposal to bring a WTO case on China's licensing regime, which was ultimately accepted by the Trump administration. This is a shocker, by the way. The Trump administration, so much against multilateral engagement, filed the second WTO case on IP issues in China. And by the way, they won that in about a year's time. And by the way, that case I've been proposing since 2001. It took 17 years for the US government to take it up and promptly was able to win that case on licensing. And that's because the US government really doesn't care about it. DOJ does, FTC does. You have a regulatory-oriented approach based largely on the US experience. But in general, we haven't been able to integrate this. Talk to the PTO, my colleagues, I would say, you know, we should really be talking about licensing and how IP gets commercialized. Well, they know examination because most of them engaged in international affairs were examiners. We can do that really well, but most of them have not had commercial experience. So you naturally have US policy that is oriented towards what the US government does. Criminal enforcement? Absolutely. Antitrust? Absolutely. Examination? Absolutely. Commercializing technology? Civil enforcement? A little harder. I've never been in court. I've never signed a licensing deal. What do I really know? This is really a fundamental a misalignment. It's misaligned with U.S. commercial interests. Frankly, it's misaligned with rule of law concerns as well. We should be very much concerned about transparency in the courts, how they function, how well cases are disposed of. We should be gathering the data as well. We're many years into this discussion around China, yet we really have not aligned up the right team to handle a lot of these issues, both for the current moment and going forward.
Thanks, Mark. Do we have questions over here? Or you just
Yeah.
Okay. I'm
Great.
sorry.
Yeah.
Please go ahead.
Thank you. I wanted to go back to the SCP issue that John raised. There's a widely expressed view that the competition law agencies in China have essentially used the competition laws to reprice the price of IP inputs, specifically SEPs, in order to lower the input costs for local device producers. I have two related questions. The first is, to what extent do you think that is true or was true and is currently true? And the second question related to that is, to what extent have concepts and doctrines developed by U.S. antitrust regulators been used for that purpose, and the influence that they've exerted internally within China for that purpose? Thank you.
Thank you.
So I think some response to your excellent questions is found in Mark Jia's article on illiberal law in U.S. courts, published by University of Pennsylvania Law Review, which grapples a lot with the ascorbic acid, the vitamin C antitrust case in the Supreme Court decision, and the problems that the U.S. courts have had in understanding what is a law in an autocratic regime, and whether the law really matters, or is it these internal directives. Shen Sabal, who was actually my classmate when I was in law school and was a dean of a law faculty in China, submitted an expert opinion in that case, where he said basically, well, the law may be such and such, but no one really follows the law. We follow internal directives, and they have the force of law. And that was, in fact, the vitamin C case. The problem is most of the time it's extremely difficult. In that case, the issue was a sovereign compulsion in terms of pricing. So they had to produce this internal document to show there was some kind of sovereign compulsion to set prices and thereby not be deemed an illegal cartel. That is one of the rare exceptions where you can actually prove this kind of thing happening. Most of the time, it's going to be based on conjecture or irregular behavior, where there's going to be a strong smell around something, but you're unlikely to locate the cause. For example, something that's bothered me for a long time, I mentioned it earlier, back in the day when I did some transactional work, the guideline for capitalizing a joint venture in China where you're going to contribute technology is that it could be no more than 6% of the value of a given project. And that 6% metric, I think, was also transposed into the antitrust context. Have I ever seen that published anywhere? No. Was it common across the negotiating table? Absolutely. I'm certain there are kinds of internal guidelines that exist, and there are probably exceptions and flexibility, as there always is, into the system. For folks, particularly the DOJ, FTC, that were, involved with China at the beginning of the antitrust law, which, by the way, just as a footnote, the Chinese fully admit that they were regulating competition well before the antitrust law. And anybody who's had experience of trying to get a merger approved in China, an acquisition, an investment, would be acutely aware that competition law in China pre-2007 included a bundle of industrial policy concerns, maybe dominated them, but it went under the guise of regulating competition. I think DOJ, FTC, and many patent lawyers and IP lawyers always ignored that first opening paragraph in almost any modern Chinese law, particularly law regulating the economy, that is in order to advance the socialist market economy. What did that mean? Well, I think we just focus on the market, forget the socialist, and let's look at how China is playing out on these doctrines. But the short answer is it's extremely difficult to locate those things. When they do exist, they're potential gold mines, but they occur, whether it's the regulators or in the courts, they're mostly highly dismissive of them. And Mark Jia, in this article, which I commended to you, points out, for the most part, courts, in looking at this question of irregular law, autocratic law, tend to come up with some kind of blended approach. They pick a little bit at what the law is written and a little bit at what they consider practice. Back in 1999, I was an expert witness in a case in the Eastern District of Texas. It was a case involving Infineon and a Chinese patentee, or the assignee of a couple of Chinese patents. And I pointed out that a license agreement to this US company of the Chinese patents was illegal for, I think, 16 different reasons under Chinese law. The laws were pretty stupid, to be candid, but it was clear that this law, this contract agreement was illegal and should not be enforced. And the experts on the Chinese side say, well, that may be the law, but we don't follow the law in China. That was actually one of the expert opinions, very similar to what Shen Sabal said in the ascorbic acid case. So there is this natural inclination, and I applaud it. I'm an American lawyer. I believe in the law, to believe that the law is being implemented as written, but I think that is frequently misguided, albeit very difficult to prove.
Thanks, Mark. John, do you have anything to add to that?
Yeah, I thought that Jonathan's question is very well posed. And I would say to the first question, is there actual evidence of repricing, then I would say yes, the Qualcomm decision was absolutely evidence of repricing, where the Chinese government came in and said, yeah, you're going to give everybody a 35% haircut. That's about as naked a form of relief as you can imagine for royalties in China. And that's actually not the most egregious example I'm familiar with. The InterDigital Huawei case was one where the courts didn't even look at InterDigital's licenses. They said, well, we're going to take InterDigital's guidance to the Securities and Exchange Commission on one of its licenses, and we're going to estimate how many sales were made by that licensee, and we're going to compute a quote-unquote rate based on that public information without looking at the license or, asking the question, did the sales that they're using in their calculations, were they actually licensed under the agreement? They didn't bother, don't confuse them with the facts. And the royalty rate that they came up with was a tiny fraction of what InterDigital actually chooses, and if that had been InterDigital's fair rate, suffice it to say that it wouldn't have had the market capitalization that it has. So the answer is yes, they do that. Your second question was, to what extent do domestic regulators facilitate that approach? And I would say that there are, the FTC Qualcomm case, I think, was kind of optically, favored. We're eating our own, in effect. But the larger problem is, how would anybody be able to articulate whether China's relief that Qualcomm reduced its rates by 35%, how would they know that was wrong? There's no intellectual framework for saying that the reduction should have been 35% or 25% or 85%. It was just a number that was arrived at unilaterally, and we could say nothing in response to that because it was a naked exercise of power that had no basis in a coherent intellectual framework. But we also have no coherent intellectual framework. So all we're saying to them is, yeah, you really shouldn't exercise power nakedly like that. But that argument doesn't help.
Oh, this is an area, maybe we have a slight difference of opinion, John, which is that I think there are ways of bridging this gap when you believe like a company like Qualcomm or InterDigital or any other company is being treated unfairly in China. But that would depend on a higher degree of transparency in the Chinese system than currently exists. And as actually the U.S. has been highly reluctant to insist on greater transparency, even though it would be neutral to both the implementer and the licensor. In the Article 63 request of the WTO this summer, the U.S. did not insist on transparency. The InterDigital case in the Shenzhen Intermediate Court, I actually went down. I was a government official at the time, and Randy Rader was in town. He was then chief judge, and we met with the judge, and we said, you should really publish your case. The U.S. government was unwilling to send a letter to the court asking it to publish a case involving a U.S. company. You want to judge whether U.S. companies are being treated fairly compared to other foreign companies or compared to Chinese companies, you're going to have a high degree of reliable information to make that assessment. I think it can be done. I notice, people are concerned now about platform companies in China, when China's cracking down on Alibaba, Tencent, and the like. And actually, as a percentage of total revenue, the Qualcomm fine was modest. The Qualcomm fine was larger, than the larger fines in absolute terms that are being imposed on Tencent, et cetera. And at that time, everybody gasped at Qualcomm, but in fact, in relative terms, it is higher. It is higher. So are foreign companies being discriminated against? I suspect so. This comes up all the time in terms of litigation, including SEP litigation. But in order to come to that conclusion, we'd have to have at least transparency over now the 160 plus SEP cases in China. And all we have is perhaps a handful of decisions to date, because those are the only ones that have been published, and nor has China been compelled to make the other cases available. So I can't tell you if foreigners are being treated unfairly or not. I suspect so. I think there's plenty of reasons to suspect so, but we have done nothing to make that argument possible, whether at the WTO or bilaterally, since we haven't insisted on transparency.
So the only, this is extended answers, I guess. The only thing that I would add to that apropos of the point that we need a better intellectual framework. We have very good competition agencies, and a lot of smart economists are employed there. I think their talents in some ways are wasted because I think that their approach to antitrust is completely static. So what I mean, so you will see, I don't know, read 250 times that the antitrust laws and the IP laws exist in harmony, and they all have the same common objective. And there's some sort of, platonic sense in which that's true. But, and from the point of view of a central planner, it's true. But if you ask, you walk up to a DOJ economist and say, is it better if prices go up or down? They'll say down, consumer welfare. And if you walk up to an IP economist or, policy advocate, is it better if prices go up or down? They'll say up. You need to incentivize R&D investment. And that basic sort of gut reaction of having opposite reactions to whether prices should go up or down and not being able to resolve the question in an analytically coherent fashion means that you've got antitrust agencies that do not act in the U.S. national interest, which is to promote higher prices in the short run for the sake of lower quality adjusted prices in the future. That should really be our position as a national net technology exporter. That's not the position of our leading competition agencies. In fact, it's the opposite of that, and that's extremely frustrating because we're not taking a dynamic approach to R&D investment. We're taking a static approach to making sure that retail mergers are efficient and that sort of thing, and that's never going to work in the long run.
The other thing also, just another footnote is the U.S. influence on China's antitrust regime is not confined to how we've handled issues domestically or what our antitrust officials have done engaging China. Also, the influence of academics, patent holdout, in particular, Mark Lemley, has a tremendous influence, particularly at Peking University, Professor Zhang Ping, who has written several books on standardization and IP, they're practically bestsellers. And her students are all over the country. And the rhetoric that we've generated here has come back to haunt us on many, many occasions.
Thank you.
Thank you for the great question. Sir, do you have a question as well?
Sure. So first of all, just thank you to the three of you for great discussion and Jonathan for a great question. I wanted to see if I could draw out a little bit more your collective take on either, let's call it significance or strategy. Much of what you have done has described in ways that, by the way, are extremely helpful. They elucidate. But I wanted to see if I could encourage, invite, let's call it and then the so what are you really saying question. And let me, and I'm not suggesting that you are obfuscating or I just am inviting you to speculate.
We can tell they're both very shy.
And so in particular, I wanted to ask kind of two directions. One is the in and the other is the out. So on the inside, you were both flagging earlier that you and some others have noticed that, for example, lots of patenting in China, in fact, even by folks outside of China, in fact, even in areas where, gosh, we, for example, don't allow those patents because of, in effect, areas of our technology that we think should be patent-free, like business methods, computers, software, so forth. On the inside, I just notice that if one were running a so-called honeypot operation, it would look, in part, exactly the way your description looks. If I wanted to encourage everybody in the world finance market, software market, Internet of Things, machine learning, artificial intelligence markets to, by the way, just give me a heads up on all the things they're thinking, I'd open a patent office and I'd say, come file your, I'll give you something, I'm gonna offer you my honey, could you please teach me for free? And by the way, could you pay me an application fee so I don't even have to hire staff? You'll fund my staff, and then you'll give me free intelligence on your artificial intelligence innovation, and that, as they say, don't cost me nothing. So I'm wondering on the inside, is that part of the significance you're drawing at? And then on the outside, what might one do with all of these patents in the world? Well, we've noticed, especially in Europe and North America, governments seem to be really interested in the regulatory parts of those governments and in the tax parts of those governments to give a very healthy respect, almost like recognizing currency for intellectual property. Perhaps not in the intellectual property parts of those governments, but in the tax. So the so-called tax box and if you're a food or safety or antitrust regulator in North America or Europe, you might not shut down a defendant after your enforcement action. You might let the defendant stay in your market and allow that defendant to charge prices based on how innovative that defendant is. As John pointed out, antitrust authorities like to evoke that they are cooperating with the notion of innovation. But then what do they pick as their measure of how innovative this defendant in the antitrust case was? They pick, well, golly gee, how many patents have you got? So we have, in effect, in North America and Europe, created a currency for just numbers of patents, like carnival tickets. And if I were in China running a system and I could give away carnival tickets that European and North American tax and regulatory officials would cash in for real money, that's another way to just create massive wealth and have Europeans and North Americans pay for it. So I just want to be clear, in this model, while it's often said pejoratively, they are the carnival and we are the good, ironically, maybe they are shrewd in perceiving that we are the carnival, and they're just subsidizing their folks with carnival tickets to trade in our carnival. Is that part of on the outflow, the significance of this, let's call it, large number of what you were describing as low-value patents?
Sure. Well, again, I wrote my dissertation on why it's wrong to simply count patents. So I'll try to keep this to 5 hours or so. There was a famous economist who would have won the Nobel Prize, except he died, named Zvi Grilicus, and he wrote a paper on counting patents and why it was the results were so the analytical results were so unpromising, defective, in fact. And he opened his paper with a joke about two women who were overheard speaking in a Catskills resort, and the first woman says to the other, "The food in this resort is terrible." And the other woman says, "Yes, and the portions are so small." And so this was his way of saying, the research is awful. There's not much good research, and the research is awful. That being said, people have been counting patents ever since then, in disregard of Zvi's advice. And so I think your point is that, or one of your points is that we have relied on this metric, and China is simply sort of taking it to the next level and saying, you want to count patents? We can count patents. We can do a lot. We'll see you and raise you a factor of 5. So I think that there's very much a sense in which that is true and unfortunate, and you see this generally, and you see this in the context of 5G and people comparing patent portfolios, and you do these comparisons all the time. So let me talk about how you can improve on that, because it's wrong. It just doesn't work, particularly when the patents are of low quality. So you mentioned people filing patent applications in China. Is that a way to learn about foreign technology? And so you ask the question, well, do foreigners file in China at the same rate that Chinese file in China, because maybe China's just growing as an economy, and so everyone wants to patent in China. It's not just, it's not a game, it's just a more attractive market. The answer is no. Foreign filing in China is increasing, but it's increasing sort of at the rate of global innovation, maybe a little bit faster because the Chinese market is growing faster, but it is not growing at nearly the rate of domestic Chinese patenting. So the explanation is not that China is simply a more attractive place to patent. Going the other way, what about Chinese patenting abroad? How are they using their foreign filings? Are they able to, is there evidence that they're able to take advantage of foreign patent filings in order to advance Chinese interests? Again, the answer is no. They actually, particularly in 5G, they're filing abroad at actually a rate that is less than you would expect, even for the real size of their economy. So they subsidize foreign filings, but as Mark said, they only subsidize you for 1 or 2 countries. So if you want the subsidy, you file in the US and Germany or the EU or somewhere, and nowhere else, because you get your subsidy. And so the average patent family size is much smaller for China than it is for the invention at large. So all of this is to say is that this is another kind of shell game, but your fundamental point is we invented the shell game in some ways, and it would be really great if somebody in the US government took the position that we will not rely on counting patents. And unfortunately, that's an extremely difficult position to take because you see judges doing it in FRAND litigation, how big is your patent portfolio, what's your share of the world total, that's your royalty rate. Somebody needs to stand up and say enough. I don't know who that person is.
Yeah, I want to add another layer onto this interesting question. I think China, bearing the brunt of so many 301 investigations from the United States, has had the U.S. as a very good tutor of what an IP regime might look like. Often a good tutor in the sense of one that can exert a lot of pressure, but not necessarily one that provides an optimized environment for China's needs. And one that's also been, we've been rather aggressive with China. So the result is, China has a 337 statute. They've never used it, but they said, gee, if the US can exclude products from coming into the market, maybe we should do that too. The reality is they never used it because they have a better process. Customs can seize goods without a court order or an administrative order that are infringing. So why do you need to go through this year-long, 18-month-long proceeding? Just seize the goods. But okay, they put it into their law. So you have a lot of US transplants, particularly in the last 5, 10, 20 years, on a system that was more or less modeled on the German system. But a transplant, and whether it's anti-suit injunctions, 337, customs remedies, what have you, doesn't necessarily mean a legal transplant that will function the same way in China as it functioned in the original country where it was created. We've certainly seen this in anti-suit injunctions, I believe. We saw this where 337 just never actually happened. And I think your question almost presupposes a higher level of importance of IP in the Chinese economy, which, and notwithstanding what I previously said, what matters is the economy, not intellectual property in China. And I don't know who said this earlier, but it's a factor. Jonathan Putnam said this. Jonathan Barnett said this. It's just a factor of production. If you're a maker economy, you're going to reduce your cost of production. And these are tools to drive down the foreign rents and make China more competitive. It's not really that complicated. When the Qualcomm case was pending, and I was hearing all these Sherman Act explanations from DOJ and FTC colleagues, I said, just stop calling it a patent. Call it coal, and let's think of it as steel. China just wants to drive down the price of coal. It's not that complicated. They have some WTO obligations, but they're really not that onerous. And I think it's this merging of mercantilism, socialism, and sophistication about IP. But it's not because they love IP. It's because they want to grow their economy.
Thanks, Mark. Thank you for the question. So I know Mark has a PowerPoint. I'm not sure if you
I
still
don't know,
want
do we have enough time? I don't know if we.
I have one question.
Sure.
We can get into the question. Maybe I'll start with you. If you want to set the PowerPoint after you're done, we can go to John, or we can continue down with our questions if you have some as well. So kind of building off what Jonathan asked and what John commented about conflicting U.S. policy, and how our national champions, how our tech companies are globally supported. Are they too big and must be regulated, or should the U.S. government do more to support them globally? And what are your thoughts on this approach? And does it seem to run counter to what the Chinese are doing, supporting their global champions around the world? So Mark, if you wouldn't mind taking that first, and then you
Yeah.
can set your deck up after
Well,
if you'd like to.
I don't think U.S. companies, no matter how sophisticated or civic-minded they may be, necessarily represent the interests of the U.S. government, its people, or its economy. We should support competitive U.S. companies. It's good for the economy. But in terms of our, policies on various issues, we should also have a less passive approach to understanding what is of the long-range interest of the United States. Now, I recall when Microsoft opened up its R&D facility in Beijing. This was around 2006 or 7. I'm really reaching back into ancient history. I apologize. But the question was, software piracy is so rampant in China. Did Microsoft at least extract some concession from Beijing to have legal software installed in government offices? There was none. And they negotiated a very successful Asian regional R&D facility. It would have been good for us if Microsoft did that. It also would have been good for us if Microsoft told us that they filed roughly 70 software piracy cases in the past 10 years and won every single one in China. You wouldn't know that because they keep on talking about piracy as a big problem, but maybe the solution is to increase their civil litigation budget. We have to be really careful about associating major U.S. enterprises as the defining entities for U.S. trade policy. And I think what we have is a high degree of passivity in the U.S. government in responding to squeaky wheels of people who complain. I do think, though, that we shouldn't hobble our companies, and we hobble them in multiple ways, and we should be acting more as partners in challenging environments like China or Russia or India. But it's not a simple answer of supporting them wherever they are or undercutting them. We do have some competitive companies, and we also need to incubate areas where we've kind of forfeited our edge, like in semiconductor manufacturing technology.
Thanks, Mark. John?
It will make me sad as an economist if the United States adopts an approach to China that sort of a national champion approach to China. I don't think that's part of our culture. I don't think that's efficient in the long run. I think it's a form of picking winners that you're doing in international competition rather than domestic competition. I don't think we're very good at it. That said, the question then becomes, what do you do when you're faced with somebody who is using a national champion model and doing so unfairly? Should you prop up your guys, or should you let yourself be taken advantage of? And that's kind of a Hobson's choice that you are facing. I would probably recommend as much as possible trying to do things like, you just mentioned Mark, maybe Microsoft should increase its civil litigation budget, Well, something you could do for everyone, and not just for Microsoft, would be to promote the filing of litigation in China to enforce
Absolutely.
your domestic intellectual property rights. So there's nothing wrong with subsidizing U.S. firms generally, not just champions, but people to enforcing their intellectual property rights, at least in theory, particularly when you're facing a determined adversary who has a strategy of weakening those rights. But you're taking collective action in response to collective action. So I think that there are ways that to improve U.S. welfare and the competitiveness of U.S. companies that don't involve, picking a single company and saying we're backing this horse. That's a big cultural shift, and I think that ultimately it's doomed to fail. I don't think we're good at this game, to tell you the truth. I think we're good at the freedom game and at the game of true innovation, where 1,000 flowers do get a chance to bloom, and we're not going to say which one is blooming in advance. It's that kind of promotion of innovation generally that I think is going to be more productive in the long run and will allow us ultimately to compete with, as an economy, with the Chinese economy.
Great, and I agree. I think you get more patents by more R&D.
Should I pull it up?
Would you like to?
Sure, I can do that.
So maybe while he's pulling up, John, I could go back on something that you said earlier. We're talking about standards organizations. There's been a conversation in Washington about should the U.S., the government, or companies be participating next to foreign adversaries in standards bodies. How do you feel about that in your scenario and as a winner takes all? Is it important for the United States to be at these standards bodies next to our foreign adversaries?
Well, purely speaking as an economist rather than as a political economist, I would say that the standard setting organizations work best when they are divorced from international politics. Mm-hmm. You're trying to create a good, efficient standard.
Is anything divorced of politics these days?
Well, we really don't have enough time to answer that question. Again, I would say I think that it would help to have a coherent intellectual framework that allowed, which in this case means what are the norms for national influence over a standard-setting organization. Mm-hmm. And I think some efforts to manipulate the organizations are actually over the line. Mm-hmm. And so the United States' role shouldn't be to ensure that the organization acts in the U.S. interest. It should be to make sure that the organization is not captured by any national interest. But is able to actually do its job as a technical standards body. I think to do that, you might need to reformulate the idea of what a standard-setting organization is. So, for example, I mentioned earlier that a standard-setting organization is a collection of people who make choices without regard to prices. Mm-hmm. They really act as an intermediary between buyers and sellers. But then they step back and say, well, the buyers and the sellers have to go, work this out between them, mm-hmm. which is an extremely inefficient and non-market approach to allocating resources. So once you introduce a standard-setting organization between technology sellers and technology buyers, you've completely screwed up the what we think of as being the efficiencies of the market. You're trying to get the benefits of a decentralized price-setting system, but you're not actually giving the standard-setting organization the obligations that it should be assuming. So there's no agency relationship between the SDO and either the seller or the buyer. The seller has to make a commitment to license on FRAND terms. The buyer has to make no such commitment. The buyer can implement the standard without any obligation whatsoever at a price of zero, and then wait for the sellers to come along and chase it down, piecemeal. This is an extremely inefficient way to run a railroad. So I think if you have a better sense of what is a standard-setting organization supposed to be doing, and what role should economics play in that, mm-hmm. given that it's a non-market activity, then you can say, and so here's the role for, or hopefully less of a role for international, for nations to get involved in that process. Because if the organization is functioning efficiently from an economic perspective, then you can, it's easier to identify behavior that is advantaging a particular country, because you'll be necessarily losing the benefits, the global benefits of efficient standard setting if one country is allowed to deviate from that optimal organizational model.
Thank you for that. Yep, please, Mark, go ahead.
Okay, so
Wolf Warriors.
originally I think I was going to present on this topic. We had an ultimate different a structure for today's discussion, which is great. But if I can bend your ears a little bit for a few final moments, the topic I want to talk about is one I want to write up about for the proposed book from this conference. And in this case, it's about the public and private international law aspects that are concerns that have arisen over China's strategies regarding SEPS. And I'm going to focus mostly in this discussion on the recent WTO request from China, from the European Union to China, to disclose certain cases, SEP cases, 4 SEP cases, 2 of which significantly involve European interests, 2 primarily American interests, followed by the EU. It was pursuant to Article 63 of the TRIPS agreement, a provision I know well because Article 63 was also part of an earlier WTO case. And that provision says, and this is basically GATT language, this is old language going back to the 1940s, laws, regulations, and final judicial decisions and administrative rulings of general application made effective by a member shall be made publicly available. And in addition, each member should be prepared to respond to a written request when there's a specific judicial decision that it believes affects its rights under the TRIPS agreement. So this is a general provision and a specific provision. A typical TRIPS agreement drafting, vague, lots of loopholes, kind of up to the WTO to fill in the gaps. Basically, test 1, specific judicial decision. The other one is a case of general application. China's position with respect to a WTO, a request filed under Article 63 in July of this year by the EU, is that that language about the specific provision that being prepared to respond doesn't mean that China has to respond. So basically, you can send us a request. It's kind of like you can send me a bill, doesn't mean I have to pay it. And that's been a position that China has maintained now pretty consistently since 2001. It only needs to be prepared to supply the request. Its position with respect to cases of general application a little bit different, but the EU request from July 6 was basically covering both legs of that Article 63 request, the EU position was that these decisions appear to give a new interpretation to existing laws, therefore it's of general application, and they should therefore be made publicly available. Interestingly, what we see in China in recent SEP disputes, including anti-suit injunctions, is China's weakness in its transparency of its court decisions has been kind of the emperor has no clothes. China's made a big deal, and they've done a lot in publishing cases in the last several years, but it's selective. And if you ever read an article about China's judicial databases, please look for the footnote. It should be an asterisk at the very beginning. The judicial database is selective. And I could tell you probably 99% of all articles that draw on the database do not make that point. Only about 70% of the cases are published. Only 1 to 2% of the cases, IP cases, involve foreigners. Think of the mischief, what lies in that 30% of unpublished cases. Are all the cases where foreigners lose there, or where we lose big, et cetera? It's a big problem. So the emperor has no clothes, but where are we learning this from is not from China. It's from other cases. The Eastern District of Texas, the New Delhi High Court. Yesterday, someone mentioned a case involving Oppo and Samsung. It's in Chongqing. There's no PACER database. We don't know it from Chinese sources. We know it because it appears in a case in Germany or the UK or the US. That's exactly what happened in terms of this EU request. Or sometimes it's in an SEC file. or securities fund. So the EU, I think, laudably was trying to say, okay, you're saying these cases either affect my rights or they're of general application, so please make them available. Okay. One thing I want to point out here is, does general application only apply to common law countries? This was China's response. This has been China's response for a long time. And the language here is, it doesn't say precedential, it says general application. I said before, that's GATT language. That's not TRIPS language. General application means informing the market. That is a completely different concept from precedent. Precedents are general application by definition, but general application is broader. Does it tell businesses how to behave? Does it suggest an optimal form of conduct? Absolutely. That is general application. You don't have to be a common law country. You don't have to be a traditional common law country, which rigidly adheres to case law, like perhaps the UK, in order to have cases of general application. And China says, you know, we don't have cases of general application because we are a civil law jurisdiction. And this is an EU case, a GATT case 1994, it means anything that applies to a range of situation or cases is of general application. That is not China's position. China's position, September 7th, 2001, was that the cases that the European Union identified had no legal effect of general application. That's not in the TRIPS agreement. It doesn't say legal effect of general application. It only says general application. So they were making this a common law versus civil law test rather than the GATT test in terms of informing market operators. And the reason this is important is China has this emerging precedential system. And cases like Conversant, Unwired Planet, Oppo versus Sharp have been recognized as cases that are guiding cases of various kinds to lower courts in China by the Supreme People's Court. Not binding, but gee, judges, you should look at this. These were well-decided cases. Is that precedent? To me, let's say that's precedent light. Those cases should be published and disclosed. If China's not making them published, then operators in the market, lawyers or their clients, won't know. This is actually a very legitimate request. Furthermore, for those of us who have been involved in Chinese legal matters the past 5 or 6 years, China's efforts to explore precedent are laudable. This was intended originally to limit corruption by local judges who would go off on a tangent and perhaps get bribed and rule against parties who should not be ruled against. But it had broader ranging implications in terms of ensuring predictability, deepening the expertise of the courts. But apparently the Ministry of Commerce or whoever argued this matter before the WTO thought, you know what, we're not precedential, we don't want to have to publish this stuff. The result is, in the world of anti-suit injunctions, 4 cases, no obligation to make them publicly available. So the other thing I want to point out, and this is consistent with my earlier observation, and I was trying to set it up for myself, and when John Putnam and I were just talking, is this issue of transparency. The U.S. did not support the WTO, did not support the EU at the WTO. There was no filing by the United States whatsoever, even though 2 of the cases, Ericsson versus Samsung, was in Texas, and the other one was Interdigital versus Xiaomi. Interdigital is a Delaware company. And the U.S. refused, much as the United States refused in Interdigital and Huawei in 2014, to even push for that most basic of legal rights, the right to look at a case and have it published so that people can analyze it and the judges can be critiqued and people understand, companies and market actors understand how to behave in the future. To me, this is a disgrace. You don't have to be an implementer, you don't have to be a licensor to believe that cases should be handled fairly and they should be predictable. Yet the U.S. did nothing. And this is, on top of it, of course, you have the Biden administration rhetoric of supporting multilateral solutions. Here was one that was delivered to us, and yet we did not move. Just the last quick point here is that Jonathan Barnett, Professor Barnett, raised the point about internal directives, et cetera. And what we are also seeing here is overt and perhaps hidden directives to the courts signaling about how cases should be decided. And a lot of pressure on what was once a fairly isolated system regarding how Chinese courts interacted with foreign courts that is now put under considerable stress and has been changing. But I want to point out that Xi Jinping, in a speech in November of last year, published in the leading party journal in January, made it very clear that China intends to promote the extraterritorial application of China's laws and regulations and to build a system for preventing and controlling IP foreign-related risks. He sent a signal to the courts. And he was aware of the issue that was building around anti-suit injunctions. And the result of that has been a lot of stress and adjustments made around China's rules regarding conflicts of law and choice of law. Traditionally, and this is where I just end up very quickly, traditionally, China's legal system has been very much a kind of fortress China system. It did not acknowledge concepts of comity readily. China has never voluntarily relinquished jurisdiction in favor of another forum in a SEPS case. China really has no effective doctrine of forum nonconvenience. The only time that a Chinese court will decline jurisdiction over a case that it started is when there's a contractual obligation to litigate in a foreign country. Otherwise, the notion that another court might be better suited to adjudicate a case is anathema to the Chinese system. China does not enforce foreign judgments, except if there's a treaty. The U.S. does enforce Chinese judgments under the Uniform Foreign Money Judgments Act. And Chinese courts have never issued narrowly tailored anti-interference injunctions. They've simply said globally, stop your lawsuit, rather than saying don't consider further infringement or validity actions involving Chinese patents. So they've taken a much more aggressive view. And I think part of this is that they have a notion of comity that is highly nationalistic, and some might even say weaponized. Also, litigation has often been of submarine nature. That was Judge Michel's words involving Ericsson and Samsung. So there's also all sorts of procedural considerations. All of this, to me, just to wrap it up, points to the problem of how to encourage China, if it aspires to be a center for global IP litigation, not just to address problems in value of patents, but also to conform to international norms of various kinds, and also wolf warrior type behavior of the type that China exhibited at the WTO, denying current realities, laudable current realities over reforms of the Chinese legal system, I don't think will serve China very well in the future, and will certainly not help China to become a center for global IP litigation. That's it.
Thanks, Mark. Thanks for putting together the deck. It's great. So, John, I would like to give you the last word, and if you could help tie up the last 90 minutes of our conversation. Mark pointed to hesitancy on the U.S. government's part to intervene. We've talked about competing policies. Where do you see us going over the next 5-10 years?
Well, you mentioned the fact that everything is politicized these days, and that's actually quite regrettable. You have, the recent Republican fascination with, America First and, unilateral action, the Biden administration's, overt reaction against that, and we've had sort of oscillation of policy. So I think that there needs to develop a I think America needs sort of an America First policy, but it needs to be something that is America First, not in the populist sense, but in the sense of what exactly are our national interests? what does that mean? How do we plan for the long term without converting to a socialist economy, without converting to a planned economy, but being able to articulate what do we have, what do we think is fair, what is a system that actually works for everybody, and that and not simply that promotes America's naked interests, but that says what is a better trade regime that can't be exploited by anybody who might want to exploit it. And unfortunately, there's very little, as far as I can see, there's very little intellectual appetite on either side of the aisle for that kind of policy innovation. And it's either sort of populist and crude or dilettantish and weak. And those are not attractive choices. So I would argue for, the academic community articulating what it means in a dynamic investment, world of dynamic R&D investment. What does it mean for a country to act in its own national interests? And what does that mean for the world economy? Because obviously a R&D focused economy has spillover benefits to the rest of the world. There's lots of kids who are alive in Africa today because people in America paid extra high pharmaceutical prices and induced pharmaceutical companies to invent. So articulating a policy that is both pro-American and that recognizes the many, many, many spillover benefits of a fair system to everyone and not just simply to Americans. And articulating those benefits both to Americans and to others, I think is extremely important. And I don't see much of the politics supporting that kind of initiative aren't there right now, unfortunately.
Thank you for your comments. Any last questions from the audience? No? Mark, unless you have last words, we can.
And I agree with everything that John said. I think a lot of the issues are also not simply a matter of the next 5 years, as if we could have a kumbaya moment and all of a sudden Democrats and Republicans decided they'd work on the national good. We have a real talent shortage. We have a STEM talent issue. We also have a talent shortage in foreign policy and Chinese language, and combining those issues. And a lot of those things will take considerable time to remedy. We have trade policies that are geared towards an America that no longer really exists. And we often don't have a very deep understanding of how other economies may be functioning in ways that threaten our, on an existential level, the kind of economy that we have today. I mean, that demands a lot. I think John Putnam said this. I think it demands a lot of creativity and innovation in policymaking. I left the government largely because I was tired of interagency warfare, so it's not simply Democrats versus Republicans. I thought I could be more productive teaching a class of 25 people about Chinese IP law than screaming at well-meaning US colleagues about how they were misguided about China's industrial policy goals. And I think academics have a very important role to play in being a voice where we can say the emperor has no clothes on particular issues. And I suspect that will continue for some time. So it's a pleasure to be here. And I've certainly benefited by the discussion. Thank you.
Great, thank you both. It's been an honor to moderate this session. If I could just quickly add to Mark's point from being in the administration, politics has nothing on turf battles, so I'm with you on the interagency. It's rough. Great, thank you all. We appreciate the opportunity to speak with you today, and we hope that you learned a little bit more from this session. So good luck to you for the rest of the day.
Thanks.